Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session of today's call, you may press star followed by 1 to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect at this time. And now turn the call over to Donna Hengeveld. You may begin.
Thank you, Shirley. Good afternoon or morning, and welcome to the webinar series on International Case Processing under UIFSA 2008, the second module. As Shirley mentioned, my name is Donna Hengeveld, and I work for OCSC, and I'm moderating the call today. Today there are going to be 4 presenters. Ann Miller, Bill Meyer, and Liza Lowe are program specialists at OCSC, and Meg Haynes is an attorney that works for us on contract and is an expert on the Hague Convention. So this webinar series was developed to be comprehensive, so some people in the audience may have attended multiple presentations and know some of this information, but for others it is brand new, and the content was developed to cover both audiences. The webinar resources include the PowerPoint presentation with notes for the slides and a set of trainer notes that provide supplemental information. The resources related to a particular module will be available on OCSC's website, and Module 1 is already there. Some of you may have seen it. If you are checking for it this afternoon, we know our website is going to be under maintenance for a brief period, so check back if it doesn't happen to be available when you look. Next slide. So the first 2 modules of the webinar series are overview modules. So this is the second overview module, and they provide background information on the 2007 Hague Child Support Convention so that you have an understanding of the U.S. goals during treaty negotiations, the process used for negotiating a treaty, and the terminology in the convention. These modules also discuss the scope of the convention and services that a central authority must provide so that you will have a better idea of what to expect on outgoing cases to a convention country. Beginning with Module 3, we will start focusing on case processing, and the most likely application under the convention is an application to recognize and enforce a support order issued by a convention country. For that reason, there will be 1 module explaining the process and forms for incoming applications and a separate one for outgoing applications. When we get to Module 5, that will cover incoming and outgoing applications for establishment of support order, including establishment of parentage when necessary to obtain support. Module 6 examines incoming and outgoing applications for modification under the convention. Module 7 will address the implementation issues and questions that have arisen over this series. And finally, in Module 8, we will discuss processing international cases from countries with bilateral reciprocal arrangements that aren't convention countries. Now, as we go through the 4 speakers, you may have questions, and if you can please enter those in the Q&A portion on the right side of your WebEx screen. If your questions are case-specific or quite detailed, we probably won't be able to answer them, and so it might be better to email, and the email will be at the end of the presentation. And then we'll get back to responses in a later module or in another format. So today we're going to go through the Module 2 material, and then at the end we'll pick up some of the questions that were left over from Module 1. And then we will have time, hopefully, for questions from the audience if we don't have them in the Q&A portion. So now I want to turn over to our first speaker, Ann Miller.
Thank you, Donna, and welcome, everyone. As Donna mentioned, Module 1 of the webinar series provided an overview of the Hague Child Support Convention. Today, we're presenting Module 2, which will focus on the role of the central authority under the convention, as well as available applications for services. Next slide. Because the convention applies to countries with various legal systems, it includes terminology that differs from the terms we use here in the United States. This slide converts convention terms to their equivalent U.S. terms. This will look familiar to those of you who attended Module 1. We discussed those terms during that training, but we would like to review them again today, especially for folks who weren't with us for the Module 1 training. When the convention refers to a creditor, it is referring to the individual entitled to receive support, the person in the U.S. that most states would refer to as the obligee or custodial parent. In some cases, the creditor may be a public body. When the convention refers to a debtor, that is the individual responsible for payment of support. In the U.S., most states use the term obligor or non-custodial parent. Probably the most confusing term to us in the U.S. is the convention's use of the word state. This is state with a capital S and means a country. The convention uses the term maintenance, whereas in the United States, we use the term support. When the convention refers to a requesting state, it is referring to the contracting state, i.e. country, that is requesting services from another contracting state. The convention country receiving and responding to the request is called the requested state. As you can tell, the equivalent terminology in UIFSA is an initiating state and a responding state. For the most part, in implementing the Hague Child Support Convention, UIFSA 2008 uses words with which 40 agencies are familiar. For example, the process that the convention outlines for recognition and enforcement of a support decision is equivalent to the process in Article 7 of UIFSA for recognition and enforcement of a registered support order. However, there are a few additional definitions in UIFSA Article 7 based on the convention. And one of these new definitions is the term foreign support agreement. The UIFSA drafters were trying to rephrase the definition in the convention for maintenance arrangement using words more familiar to the United States. A foreign support agreement is an agreement for support in a record that is enforceable as a support order in the country of origin and has been authenticated by, registered, or filed with a foreign tribunal and may be reviewed and modified by a foreign tribunal. It is not the same thing as a U.S. separation agreement, which is enforceable as a contract. Section 710 of UIFSA discusses the process for recognition and enforcement of a registered foreign support agreement. Next slide, please. There are two additional terms we will use during this presentation. The convention often refers to the competent authority. There's no definition within the convention because the identity of the competent authority will vary among convention countries. It also depends on the context of the action. For example, the convention requires the competent authority in the requested state to declare without delay whether a decision registered for recognition and enforcement is in fact enforceable. Depending upon the country, the competent authority may be the court, an administrative agency, or both. Another provision within the convention provides that if there is a challenge to a document submitted for recognition and enforcement, a complete copy of the document concerned, certified by the competent authority in the state of origin, shall be provided promptly. It will be up to the state of origin to determine who the competent authority is to certify the requested document. Some of the slides in Module 2 refer to a contracting state. That term is a shorthand reference to a country that has ratified the Hague Child Support Convention. In the U.S., we often refer to that country as a convention country. Next slide. All right. Each convention negotiated by the Hague Conference on Private International Law requires a contracting state to designate a central authority. The central authority is an agency or organization that is designated to play a key role in the implementation and operation of the international treaty. Article 5 of the Convention lays out general functions of central authorities. They must cooperate with each other to achieve the Convention's purposes, and they must try to resolve as much as possible any difficulties that arise in the implementation of the Convention. Article 6 of the Convention lists specific functions of a central authority. For example, the central authority must both transmit and receive applications. Other Convention provisions place additional obligations on the central authority. These obligations emphasize the need for international cooperation among contracting states. The functions of the central authority may be performed by public bodies or other bodies subject to the supervision of the competent authorities of the contracting state. That means that countries will vary regarding what entity serves as the central authority. However, each country is required to keep the Permanent Bureau informed of the identity and contact details of its central authority. That information is listed on the Hague website as well as in the country profile that we discussed in Module 1. In the United States, the central authority is the Secretary of the Department of Health and Human Services. The Secretary, in turn, has designated OCSC as the entity to serve as central authority. Article 6 of the Convention lists two specific functions of central authorities. They must transmit and receive Convention applications under Chapter 3, and we will discuss those applications in a bit. They must initiate or facilitate the institution of proceedings in respect of such applications. Article 6 also requires the central authority to take all appropriate measures with regard to those applications. The U.S. delegation played a major role in ensuring that the list of measures in Article 6 is comprehensive. One of the specific measures is helping to locate the debtor or creditor. As it does now, OCSC will use the FPLS to assist Convention countries when they do not know the U.S. state where the creditor or debtor resides. The information OCSC returns to the Convention country is only the state of residence, and we are not allowed to provide the residential or employment address information. As happens currently with our foreign reciprocating agreements, HHS has designated state child support agencies to provide the majority of specific central authority functions under Article 6, which are case processing functions. That means that applications for Convention cases will continue to be received and transmitted at the state level, and state child support agencies will be responsible for processing those applications. In addition to providing locate assistance to Convention countries, OCSC will play a critical role with regard to implementing the treaty in the United States. OCSC will provide policy guidance on implementation issues and will provide both state child support workers and Convention countries with tools and training resources on implementation in the United States. It will continue to respond to customer service inquiries from a number of constituents, which are listed on this slide. The Convention outlines a number of responsibilities that the requesting central authority, so think initiating, has when transmitting applications to a Convention country. This slide summarizes them. In its role in the U.S. as a requesting central authority, a 4D agency must help the petitioner complete the application and ensure that the Convention application includes all the necessary information and documents. The country profile, which we talked about in our first module, is an excellent resource for identifying forms and information needed by the requested state, or think responding country. The 4D agency must also review the application to ensure it complies with the Convention. States need to decide who will be conducting that review. Will it be at the local level or centralized with a unit that focuses on Convention cases? Note that this review is limited to compliance with the Convention. It's not intended to be a determination about the merits of the application. Once it is satisfied that the application complies with the convention, the requesting central authority, the child support agency in the U.S., must transmit the application on behalf of the applicant to the requested central authority. The application must include a transmittal, one of two mandatory forms under the convention. There is no need to include certified documents unless the requested contracting state asks for them. Article 45 of the convention addresses translation. It authorizes the requesting central authority to charge an applicant translation costs unless those costs are covered by the country's system of legal assistance. And we will be discussing translation issues more during Module 7 of the webinar. With that, I'm going to turn it over to Meg Haynes, who will talk about the role of the requested central authority. Meg?
Thanks, Anne. The Convention also outlines responsibilities that the central authority has when receiving applications from a convention country. And this slide summarizes the measures that Article 6 requires the central authority to take, if they're appropriate, when the central authority receives an application under Chapter 3. So in the United States, a 4D agency, as a requested central authority, must take these functions with regard to the application. Provide or facilitate the provision of legal assistance where circumstances require, help locate the debtor or the creditor, help obtain relevant financial information about the debtor or creditor, including income and the location of assets, encourage amicable solutions with a view to obtaining voluntary payment. So, that's something that we've increasingly begun talking about in child support cases, and examples would include the use of mediation, conciliation, or similar processes. The Convention requires the requested central authority to facilitate the ongoing enforcement of support orders, including any arrears, facilitate the collection and expeditious transfer of support payments, facilitate the obtaining of documentary or other evidence, provide assistance in establishing parentage where necessary to recover support. This next one is a long one. Initiate or facilitate the institution of proceedings to obtain any necessary provisional measures that are territorial in nature and the purpose of which is to secure the outcome of a pending maintenance application. So that's a lot of jargon. Some of the wording is a little bit unfamiliar to us because it's wording that needs to work in an international context. But what that basically means is that you may be asked to freeze the debtor's assets pending the outcome of any legal proceeding. And the measure must be provisional, meaning it's temporary, territorial in nature, which means, you're obviously limited to assets that are within the territory of your state. And the purpose of freezing the assets has to be to secure the outcome of the child support proceeding. In other words, to ensure that there's income or assets against which the child support can be enforced. And then the last mandatory function under Article 6 of the Convention is facilitate service of documents. So you'll see these are all things that 4D agencies are already doing. You'll also notice that there are a lot of verbs like help, encourage, and facilitate in that list. The U.S. would have preferred stronger language, but that was an example of one of the compromises that we made in order to make sure that the Convention did include a detailed list of responsibilities. So we're very happy to see that list in Article 6. Next slide. Article 12 of the Convention was also important to the United States because this article contains time frames. We're used to in the 4D world having a lot of time frames, but for a Hague Convention, that's very unusual. And it's just another example of how important it was to the U.S. that we make sure the treaty is practical and addresses issues of case processing delays. So let's talk about those time frames that are in the Convention. The Convention requires the requested central authority to acknowledge receipt of the application within 6 weeks. And there is a mandatory acknowledgement form that every convention country has to use for that acknowledgement. That form, in addition to acknowledging receipt of the application, will inform the requesting state what initial steps have been taken. It identifies any needed additional documents, and it provides contact information. So you can see it's really patterned after the acknowledgement form that we use in the United States in intergovernmental cases. And you can expect to receive that type of information in the acknowledgement form from a convention country within 6 weeks of your sending it to the country. Of course, in the United States, 4D agencies are subject to tighter time frames. So under federal regulations at 45 CFR 303.7, the central registry in an intergovernmental case must acknowledge receipt and identify any missing documents within 10 working days of receipt. So, Article 12 lets you know what you can expect from another convention country, but in the United States, 4D agencies are obviously still subject to federal regulations, which have tighter time frames. Another time frame within the convention talks about acknowledging the status of the application, and the requested central authority within 3 months of the acknowledgement is required to provide a status update to the requesting state. Next slide. Let's assume that you have forwarded an application under the convention to another convention country. It comes before the central authority in that requested state. On the prior slide, we said that the requested central authority is supposed to review the application, send an acknowledgement, and that acknowledgement is to identify any missing documents. So the question to ask is, are there limits to that review on what the central authority can or cannot do when it reviews the application? And the answer is yes. The requested central authority cannot reject an application just because additional documents or information are needed. It may ask you as the requesting central authority for additional information. The convention even allows a country to suspend processing the application until you send them the information or documents that are requested. But it can't just flat out reject the application. Again, this is different from federal regulations that 4D agencies continue to be subject to. Those federal regulations require you to continue processing the case to the extent possible. You're not allowed to suspend processing like a convention country can. Also notice the time frames in the convention that contracting states will be following. If a requested central authority asks you to provide certain information and 3 months come and go and you have not provided that information, then the requested central authority can decide not to process the application any further, and they have to inform you of that decision. Again, the time frame in the convention is 3 months, and that would be different from what's in federal regulations. Second, the requested central authority may refuse to process an application only if it's manifest that convention requirements are not met. And according to the explanatory report to the convention, manifest means it has to be clear on the face of the document that the requirements aren't fulfilled. For example, if the application seeks determination of custody, and that's the only thing they're asking for, and custody is, not within the scope of the convention, then it would be manifest on the face of the document that the convention requirements are not met. And the reason there's that strict standard that it has to be manifest on the face of the document is because the requesting central authority is supposed to have already reviewed the application, right? What Ann talked about, to ensure that it complies with the convention. So So there should have already been a review that takes place in the first stance. If the requested central authority does decide to refuse to process the application because it is manifest on the face that the requirements are not met, then it must provide prompt notice to the requesting state. And according to the explanatory report, if it's unclear whether the application satisfies convention requirements, it's preferable for the requested central authority to go ahead and process it and not make any decision that's really more properly left to the competent authority acting on the application. Next slide. Article 42 is a provision of the convention that's really not going to come into play in incoming convention cases to the United States. 40 agencies and attorneys do not represent an individual applicant, so it won't apply when we are acting on the convention application. But we wanted you to be aware of it because it may come up on your outgoing cases. Ordinarily, a requested central authority will process the application quickly, and there won't be any additional formal documents needed for assistance. But there are some countries that under their domestic law have to have a power of attorney in order for the central authority to act on behalf of the applicant. And in that limited circumstance, Article 42 comes into play, and it permits a central authority of the requested state to require a power of attorney from the applicant in order to represent the applicant before authorities in that country. So hopefully you won't encounter that very often. Next slide. Article 12 of the Convention outlines basic requirements for effective case management that apply to central authorities in both the requesting and requested states. Central authorities are supposed to keep each other informed of the person or unit responsible for the case and about the progress of the case. They are supposed to provide timely responses to inquiries. They are supposed to process the case as quickly as a proper consideration of the issues will allow, and they are supposed to employ the most rapid and efficient means of communication at their disposal. So look at the adverbs, timely, quickly, rapid. Again, the emphasis is on speed, and when you couple this language with the time frames discussed earlier, it's evidence how important it really was to the delegates of this convention that case processing be streamlined and that central authorities cooperate with each other. Next slide. The applications that are available through a central authority are listed in Article 12 of the Convention. In the United States, you need to look at Section 704 of UIFSA 2008. Although the U.S. delegation, as we mentioned under Module 1, really argued strongly that the same applications should be available to both creditors and debtors, that position was ultimately not successful. So you'll see there is a slight difference in applications that are available to the creditor versus those that are available to the debtor under the convention. The consensus reached was that the following applications must be available to a creditor in a requesting state seeking to recover maintenance under the convention: establishment of a support decision, including, if necessary, determination of parentage, recognition and enforcement of an existing support decision, enforcement of a decision that was issued or has already been recognized by the requested state, and modification of a decision. There was also consensus that the following applications must be available to a debtor: recognition and enforcement of a decision, suspending or limiting enforcement of a prior decision in the requested state, and modification of a decision. What you'll be able to tell from looking at this slide is that under the Convention, there is no application available to a debtor through essential authority to establish support or determine parentage. Now, there may be other avenues open to the debtor. For example, there may be an arrangement under a bilateral agreement that provides broader protections and services than those listed under the Convention. But under the Convention itself, the debtor has just those limited applications that are available. And in later modules, we will discuss each of these applications in detail. So probably it would be best to defer specific questions about these applications until those later modules. Next slide. The next few slides address some implementation questions that have arisen. The first question is, does it matter where the applicant lives? And the answer is yes, it does. Article 10 of the Convention sets the threshold criteria that the creditor or debtor must meet when seeking the assistance of essential authority under that article. The applicant has to be in the requesting contracting state. The applicant must be the creditor or a person acting for the creditor who is seeking to recover maintenance in another contracting state, or the applicant must be the debtor against whom there's already a maintenance decision. And the third requirement is that the application must be one of those applications that were listed on the prior slide. So in the example depicted on this slide, we have a custodial parent that has an order issued in France, which is a convention country, but she resides in Switzerland, which is not a convention country. And because she does not reside in a contracting state, she cannot file an application under the convention. Next slide. The convention distinguishes between an application through essential authority and a direct request to a competent authority like a court. An essential authority is only required to assist with an application. So the question is, can an applicant request services from any essential authority? The answer is no. In order for an applicant to receive free services of essential authority under the convention, the application must be made through essential authority in accordance with Article 9 of the Convention. That article requires that an application must be made through the essential authority of the contracting state in which the applicant resides to the essential authority of the requested state. And residence excludes mere presence, such as the applicant just passing through the country. So in the case scenario depicted on the slide, we have an applicant who resides in Germany. That means that she will work with the central authority in Germany, which is the Federal Office of Justice. Once it is satisfied that the application complies with the convention, the Federal Office of Justice will transmit the application to the central authority in Spain, where the debtor resides. Next slide. The convention also allows an applicant to make certain requests directly to a competent authority in the contracting state. In other words, the applicant can file directly to a tribunal. Such cases don't involve any services by the central authority. So in the United States, if a applicant files directly with the court, that would be considered a direct request under the convention, and the person would not receive any 4D services. The relevant section of UIFSA is Section 705. So one of the things that is you need to be aware of, at least in the 4D world, is that a direct request under the convention or a direct request under Section 705 of UIFSA is not the same thing as a direct application for 4D services. So don't get those two things confused. Next slide. So what if a country's internal law does allow essential authority to accept an application sent directly to it by an applicant rather than it being sent through the central authority. As I mentioned, such a case is not considered a convention case, and in the United States, that brings us to Section 307 of UIFSA. When a state legislature enacted UIFSA 2008, if you can recall, your state legislature could choose between Alternative A and Alternative B of the Model Act. Both alternatives are based on language in the Federal Preventing Sex Trafficking and Strengthening Families Act that Congress passed in 2004. If your state enacted Alternative A, you as the 4D agency must provide services to all petitioners regardless of where they reside. That includes all direct applications for 4D services received from petitioners living in other countries. If your state enacted Alternative B, you as the 4D agency must provide services to a petitioner who resides in a state as defined by UIFSA. You must also provide 4D services to a petitioner who requests services through a central authority, and that central authority may be a Hague Convention country or a foreign reciprocating country, an FRC. But under Alternative B, if you receive a direct application for 4D services from a petitioner who lives in a foreign nation that's not a Hague Convention country or an FRC, your state has discretion about providing 4D services. Similarly, if the person applies directly for 4D services and is in a Hague country but doesn't go through his or her central authority, then you have discretion about providing services. And if you get a direct application from a foreign petitioner, then you would be applying Article 1 through 6 of UIFSA, not Article 7, because it would not be considered a convention case. Next slide. If there's an existing order that the applicant wants the requested state to recognize and enforce, does it matter which country issued the order? And the answer to that implementation question is yes. An applicant may use the convention's procedures for recognition and enforcement of an order only if a contracting state issued that order. But it doesn't have to be a decision of the requesting state so long as the issuing state is a convention country. So let's take an example. We'll assume that the creditor was living in France and got a support order there. And later, the creditor moves to Germany, and we'll assume that the debtor is living in Austria. So we have a French order, a creditor in Germany, and a debtor in Austria. France, Germany, and Austria are all contracting states to the Hague Child Support Convention. And so the creditor living in Germany can request recognition and enforcement in Austria of the decision made in France because it was a convention country that did issue the order. So now let's ask a similar question in the context of modification. Next slide. If there's an existing order that the applicant wants the requested state to modify, does it matter which country issued the order? And the answer to this question is no. In contrast to an application for recognition and enforcement, an application for modification under Article 10.1f or 10.2c of the Convention can be based on an order issued in any country. But whether a non-contracting state decision, so in other words, an order that was not issued by a convention country, can be modified will depend on the law of the requested contracting state. So let's talk about how that will work in the United States. Let's assume that, well, in the United States, a foreign support order has to be recognized before it can be modified. So what procedure you'll use for recognition and enforcement will vary depending on whether this foreign support order was issued by a contracting state. So if the convention application seeks modification of an order issued by a contracting state. So everybody is a convention country in that scenario. Then the order will first be registered for recognition and enforcement, Article 7 of UIFSA. And Article 7 also addresses modification of the order. But let's assume the creditor in a contracting state requests modification in the U.S. of an order that was not issued by a convention country. That's an authorized application under the convention. The creditor can do that. But because the order was not issued by a contracting state, the mandatory recognition provisions of the convention don't apply. And what that means is that in the United States, a tribunal would be applying Article 6 of UIFSA with regard to recognition and modifying of the underlying order, not Article 7. And if the tribunal is able to recognize the order, it will apply its state law regarding modification. If it modifies the order, Section 615 of UIFSA provides that the modified order becomes the controlling order, and now we have a new modified decision that can later be sent to any contracting state for recognition and enforcement, because at that point we have an order that's issued by a contracting state. So with that, I'm going to turn it over to Bill, who's going to talk about specific measures under Article 7.
Thank you, Meg. Hello, everyone. As Meg said, we're going to talk a little bit about specific measures under Article 7 of the Convention. A request for specific measures is a request for limited assistance rather than a convention application. It is similar to the Child Support Transmittal Number 3 that we use often in the United States. Under Article 7.1 of the Convention, there are two possible situations in which a request for specific measures might be made by a central authority and action is required by the requested central authority. The first situation is a request that is preliminary to a convention application. For example, a request for assistance made to the central authority to verify whether the debtor resides in the state to which the requesting central authority wants to send a support application. The second situation is a request for assistance that will help determine whether an application will be filed in the future. For example, the request could be for information about the debtor's income that will allow the requesting state to establish a support order that it will later seek to be recognized and enforced in the requested state. A request for specific measures under Article 7.1 is limited to the 6 Article 6 functions noted on the slide. If you saw a previous version of this slide, there might have been only 5 listed, but in fact there are 6 functions applicable here. The requesting central authority should list reasons as to why the measures are needed. If the requested central authority is satisfied that the measures are necessary to assist a potential applicant in making an application under Article 10, or in determining whether such an application should be initiated, it must take appropriate measures. Next slide, please. Under Article 7.2, there is a different type of specific measure that might be requested. Article 7.2 applies even if both the debtor and creditor live in the requesting state, so long as there is an international element to the child support case. When a request is submitted under Article 7.2, the central authority has discretion in deciding whether to take the requested specific measures, unlike request under Article 7.1. One reason for the discretion is that the specific measures referred to in subsection 2 are not restricted to the 6 measures mentioned in Article 7.1. Next slide, and we're going to talk a little bit about central authority costs. Requests for specific measures under Article 7 do not have the same benefits, such as cost-free services, as Chapter 3 applications have. Article 8 prohibits central authorities from imposing any charge on an applicant for their services under the Convention. The exception is for exceptional cost arising from a request for a specific measure under Article 7. A requested central authority may recover such exceptional costs, but only if the applicant provides prior consent to the services at that cost. The consensus of convention delegates was to require prior consent because Article 7 requests for specific measures may trigger considerable costs, even though it is possible that the result will be that no application is made. Next slide, and I think we're going to hear from Liza or Donna regarding questions from Module 1.
Thanks, Bill. This is Donna, and I've got some questions that Liza's going to answer that came up in Module 1. So the first question is, what's the latest on the Hague forms? When will they be available?
Thanks, Donna, and hello, everybody. We have gotten quite a few questions about Hague forms, so we want to provide some information today and some updates. The Hague Convention forms, as Meg has described on the modules, are to be used for case processing between convention countries. The convention forms include a mandatory transmittal form, a mandatory acknowledgement form, and 12 recommended forms, which are grouped together by 4 types of applications, which you'll recognize when Meg was describing the applications on the slides today. The 4 application types are recognition or recognition and enforcement of a decision made or recognized in the requested state. The number 3 is establishment, and 4 is modification. Once the convention is in effect, U.S. child support agencies can expect the following in regard to forms. On incoming cases, all cases coming from a convention country must be on convention forms. So this will be the mandatory transmittal and the recommended forms, whichever ones are being used for that application. OCSC, as the U.S. Central Authority, communicates this requirement to use the Hague forms on incoming cases to all convention countries on our country profile. This is the way we will let countries know that we expect incoming cases to be on Hague forms. U.S. states will use the mandatory acknowledgement form in response to an incoming case. Now, on outgoing cases from the U.S., U.S. states must use the mandatory transmittal form for all outgoing cases, of course, and almost certainly will use the recommended convention forms as well, dependent on which application. Now, under the convention, a convention country may require use of a form that is different from the convention form, or a country may indicate that it does not have a prescribed or preferred form. However, in our analysis of the country profile of other convention countries, many have indicated that they do want to use convention forms, so we expect that to be the norm. U.S. states should expect to use Hague forms in outgoing cases, but simply just we recommend you double check the country profile for the forms requirements of any given country, and that's just a best practice in general when you're getting a case together to check the country profile. And in regards to forms, just to see that they're not looking for something different. Now, the Hague forms are available now on the Hague website as they've been up and are being used currently by convention countries, and we have links to the forms that are on the Hague site on the OCSC International website. You will see, if you haven't been there, when we discussed it after the last module, we have a heading on our international website that's called Hague Convention on the International Recovery of Child Support, and there's all kinds of links there. Also, we did publish Dear Colleague 1621, which describes the federal clearance process for using the Hague forms. And that, Dear Colleague, does describe some of the things I've just been mentioning and provides links and other information about the forms. But the big news and what you're probably waiting for is when we're going to publish English PDF fillable forms on our website so that they will be easily accessed by you and also OMB approved. which is also critical for us. And the news for us is we do expect these OMB cleared PDF English fillable forms to be available possibly by the end of the week and certainly by the end of the month. We will be sending out notice to states by e-flash, by email, when we do post these, but we will be posting them on the international OCSC webpage, very close to the same list of items as the Hague Convention links that I just mentioned. So on our main international webpage, we will have a drop-down or expandable section that is devoted to these Hague fillable forms. So you can just look on the website, too, in the next week or so. We did get a question that came in during the call today about emergency clearance. And without going into too much detail about the OMB approval process, yes, we have received the OMB emergency clearance for the forms, and the forms that we post in the next week or so will have an OMB clearance number. This is an emergency clearance, and it's good for the next 5 months, and then by that time we should have the regular 3-year clearance on there. So no worries, we will have an OMB cleared form set by the end of the month, if not before. Finally, we also got a comment or question coming in about whether there was a power of attorney form in the Hague website, forms set, as Meg was talking about that on an earlier slide. And the Hague form set does not have a specific power of attorney form, so you might want to look on the country profile to see if they indicate what form they might like for that, or just check with the country to see what you need in that regard. Okay, I think that covers it. And thank you very much. Please be in touch with us if you have questions about forms. Donna?
Okay, well, I've got another one. So will the forms need to be translated into the official language of the convention country?
Thanks, Donna. To address this question, I'm going to talk a little bit about translation requirements for the convention cases more broadly, and then talk about the forms in regard to translation. The convention requires, under Article 44, that an application and related documents be in the original language and accompanied by a translation. The translation should be in either the official language of the requested state or another language the requested state has indicated on its country profile. So when sending an application to a convention country, the first step is to look at that country profile and to find out the language requirements of that country. The country profile language requirements are found under the first section of the country profile. So if you all are looking around in the country profile, you can find this out. It's the first section, which is called the designated central authorities, and then under item 3 is language requirements. And there's 4 fields of information under this section. And the first question asks, the question is, does the name of the state, so be U.S. or Poland or Portugal, require that an application and related documents be accompanied by a translation, and if so, in what language? So it's very clear. And the choices are the country could answer no or yes. And if yes is selected, then the country has to indicate what the official language is or what the language preference is. So in the instance of the U.S. country profile, of course, we're going to say that we do want the documents accompanied by a translation. And, of course, we've checked our official language of the United States. So that's what we expect on incoming cases, that the documents, if they're not in English, to be translated, to have a translation in English. This is a good time to note, too, that there's a separate language requirement in the same section on the country profile that's not about translating documents, but it's about communications between central authorities. And it talks about that there are, which is helpful to us, there are only 2 language choices for communications between central authorities, and they're English and French. So the item D on the country profile asks that for other communications between central authorities, and it says, does the name of country object to the use of either English or French, so that the country filling out the profile can say either they don't object to either, and communication can be in English or French, or they can object to one or the other. And of course, on our country profile, we are objecting to the use of French, and that means that communication on incoming cases should be in English. And the flip side of this, which is good for us, is that in the most part, in our looking at the other country profiles under the Hague Treaty, most countries will allow us to communicate with them in English. But again, you want to look on the country profile to find out. And so communication is not documents and applications, but it's emails, letters, calls, and that will make things easier for us to be able to use English. Now back to forms. We have heard on past trainings, as Meg said, that the forms were designed to minimize the need for translation. For example, the forms use, and the Hague forms, use a lot of check boxes and short answers. Now, we're working with the Hague Conference Permanent Bureau to obtain translated versions of the forms for each of the convention countries and hope to have more information soon. At this point, as I said, that the forms that we are going to be posting are going to be in English. The German Central Authority in Bonn has separately prepared some German-English bilingual forms to assist us in working cases with them. So that will be helpful in what we expect will be, a significant caseload eventually, at least with Germany. And also, this will help us in working with other German-speaking countries. And we hope to share those forms as soon as possible. So again, just a reminder that we strongly encourage you to not only read the other country's country profile when you're working a case with a new convention country, but also we would encourage you to reach out to the central authority in that other country before you go to great lengths and jump into translating documents, just in case you can confirm some of the translation requirements with the other country. It doesn't hurt to reach out to them, especially since we can do it in English for the most part, and just confirm what they're looking for in terms of translations. And finally, as Ann and Meg have mentioned, in Module 7, we will have more on the topic of translation later in the webinar series. Thanks, Donna.
Thank you, Liza. So another question for you. Will the current IRG layout change, in particular thinking about the length of foreign postal codes compared to zip codes?
Thanks, Donna. And we appreciate this question. At this point, we are currently looking at what changes may be possible to the IRG to adapt fields for international postal codes or longer international addresses. We appreciate the question, so we can look at this. At this point, the IRG interface will not be immediately changing, but we welcome your suggestions, and please do be in touch with us about that, and we'll work with the IRG folks here in our office. Now, associated with this question is whether the changes may be needed to some state systems to accommodate these longer international addresses. And states, of course, have been storing international addresses on their state systems for many years as you've been working these cases. But we understand that with the implementation of the convention, some states may be looking now at new ways to adapt their state systems to better accommodate international addresses. Some states with newer systems may have some innovative approaches to this, and we encourage states to reach out to learn from one another. And please let us know how OCSC can help. Thanks, Donna.
Thank you, Liza. So the last question that we had to respond to today from the last module was, there's still a couple weeks before the convention goes into force on the 1st of January. So do you have any tips for what to do with cases until January 1?
Well, thanks, Donna. We sort of have a shorter answer on this. We have one recommendation, and that is that basically starting around now, mid-December, we are recommending that states that have a case in the queue here and are about to send a new case to a current foreign reciprocating country that is also a convention country, and that we will have a convention relationship with in about 2 weeks, we encourage you to hold that case and wait and send it as a convention case on convention forms after January 1st, 2017. And after some conversations with at least one FRC partner and internally, we recommend this just to limit the confusion. Since it is holiday time, it's likely that any case we send now won't be processed until the new year, in which case it just invites a little confusion if it's not on Hague forms at that time. And the United Kingdom is one of these countries. They are both an FRC and they're also a Hague country. And they have specifically informed us that that any case that they do receive even before January 1st, but they aren't able to process and don't get to it in their office until after January 1st, that case will be returned to the U.S. if it's not on the convention forms. So definitely for the UK, hold your cases and wait till after. And we just suggest as a general practice, maybe to hold your cases. But let us know if you have any questions about that. And thanks very much.
Okay, thanks, Liza. So, some of you were on the first, attended the first webinar, and we know that there still are some questions that you're probably waiting for your response. And we are still working on those, and they will be addressed in an action transmittal. Now, we did get some other questions here in the Q&A, and one person asked, will the answers to Module 1 questions be posted or provided?
This is Ann Miller at OCSC. Yes, they will. We're working on those. The ones that Liza didn't address today, we are working on them very hard, and we're preparing an action transmittal that will hopefully be published soon. So if you have questions, feel free to send them in to us. But in addition, the answers that Liza has just talked about for Module 1, she's indicated where those answers information can be found on the website, and we will, as necessary, include those in the action transmittal.
Thanks, Ann. Now we have another question. Is there a place where we can find what countries are convention countries?
Thanks, Donna. The convention countries are listed. The best resource is on the Hague website. So please look on our website if you aren't able easily to get to the Hague website, and you can find links to the convention website, and that's the best list. We do have lists in the Module 1, I believe, of those countries as well. But the best resource, we're always going to say, please go back to the Hague website because they'll be the most up-to-date since things tend to change.
Thanks, Liza. Excuse me. We have another question asking why is there a delay in processing convention cases?
Donna, this is Ann Miller. I think when you say why is there a delay, I'm unclear what the questioner is referring to. I'm going to assume you mean until January 1st, and that is when the convention is officially in effect for the United States. It was ratified and deposited back in August and September, and then we had a quarter and 3 months until the convention entered into force for the United States, and for us that date is January 1st. So that is when we start using the convention procedures and forms. It's also when Article 7 of UIFSA goes into effect.
Thanks, Ann.
Donna, there's a question on the chat, on the Q&A, which was a little higher than you read a minute ago, and it says, who would be responsible for the costs incurred with specific measure requests the creditor, or the central authority of the requesting state. And Bill spoke about this in his slides. And Article 8(2) of the Convention indicates that central authorities may not impose charges on applicants except for exceptional costs arising from a request for a specific measure. And it's important to note this would be only if there's an exceptional cost, and the treaty also requires that prior consent be obtained from the applicant. And so the answer to the question is the cost would be imposed on the applicant, but prior consent would need to be provided, and it would have to be considered exceptional costs.
Thanks, Anne. Now, someone did have a question about the cost of translation. Can it be recouped under Article 8 from the applicant?
That is another, hold on just a second, Donna. Bob, do you want to take that one? Sorry. This is Bob Keith from our General Counsel's Office, who's joining us here today.
The convention clearly requires that costs of translation shall be borne by the requesting state unless otherwise agreed upon by the central authorities. Whether that cost is then passed on to the applicant or not will depend upon whether your state is a cost recovery state.
Thanks, Bob. Now, someone else wants to know if training is going to be available to U.S. judges for handling Hague cases.
This is Yvette Riddick from the Division of Policy and Training, and yes, we are. We're already reaching out to judicial organizations such as the National Center for State Courts and NCJ, FCJ, and we are also working with the National Conference for State Legislators. So we will be reaching out to the judicial side and providing webinars for them as well, using some of the attorneys that work for us in our department and people like Meg, who's with us today.
Thanks, Yvette. And then there's a question about the recordings, if they're going to be made available.
Hi, this is Ann Miller. We are recording these webinars. We are working very hard to get the PowerPoint and the notes on the website. The process for posting the recordings, we have to go through some additional steps, and we have decided to hold off on that posting in the next couple of months and to focus primarily on the training materials. We agree they'd be very helpful. It's a time issue, and we will let you know when we are able to post those. But we have to go through additional steps to make them compliant within the department, so we're holding off for now.
Thanks, Ann. Now we have a question about how to handle a case if there's a U.S. tribe. I guess I'm assuming a tribe with a 4D child support program. Are they bound by the convention or by UIFSA 2008?
Well, they're certainly not bound by UIFSA. Tribes are not required, as states are, to enact UIFSA. And so unless they chose to enact UIFSA, they wouldn't be able to process cases under the convention consistent with Article 7 of UIFSA. Tribes, of course, may be 4D agencies, and all tribal members are citizens of the United States. They will be able to take advantage of the convention. I think we'll probably be issuing guidance or advice on exactly how that can be facilitated. But tribes will not be expected to operate as states are required to in accepting applications for services from convention countries. there will be a mechanism for tribal members to submit applications using the advantages of the convention. But as I say, those details, I think, are a little bit too complicated at this point and will require further guidance.
Thanks, Bob. Now, someone else wants to know what recourse there is if countries fail to comply with the timelines in Article 12, and wonder if OCSE wants to know about countries that aren't following those timelines.
This is Ann, and yes, we would very much like to know if there are difficulties with other states meeting the timeframes. The Hague Conference will be having periodic special commissions to go over the how the convention is working and operating, and that would be the time that we would address these concerns officially and formally, and we can also do it when we learn about it as well, and we can assist with correspondence with that country if there are difficulties processing cases.
Thanks, Ann. And another question is OCSE intending to respond to Article 7 special measure requests, or are those going to be delegated to states to handle?
This is Ann, and they are delegated to states to handle specific measures as limited services. There's an overlap, however, in that, as I mentioned, the OCSE as a central authority has the responsibility to provide locate assistance, and that if the other country doesn't even know where to start in terms of sending a case to a state, so OCSE will provide that support. We will then inform the convention country what state the debtor resides in, and they would then send the case to the state. They may ask you to do locate to confirm that he or she is in your state as a specific measure. But the Article 7 request would be for state agencies to process.
And the follow-on to that, are there forms for those types of applications or requests?
Go ahead. No, there's no specific measures form under the Hague.
Thank you.
Donna, to some extent, we're in uncharted territory here, but this is one of the most important aspects, a unique aspect of this particular convention that the United States was able to ensure was included. And there's great potential for the use of special measures. And there could be some central authority to central authority requests at the federal level. But we see a great deal of opportunity here to facilitate case processing, particularly in cases where we may be able to establish an order here in this country and not even have to use all of the formal aspects of an application through the convention. For instance, we may be able to identify assets. We may be able to facilitate establishment of paternity. We may be able to locate somebody who's subject to long-arm jurisdiction. These are all just potential examples of things that we hope we will be able to utilize as we experiment and determine just what we can do exactly under Article 7.
Thanks, Bob. That's really helpful. Now, I only see one more question in the list of Q&As. So people do keep putting those in if you have questions. The last one I have here is a question around, is there a central resource listing what constitutes legal paternity adjudication in each country?
This is Meg. That's something that is addressed in the country profile. There's a section related to parentage, and a country can indicate what constitutes a presumption of parentage in its country, and so that would be the best resource that I would suggest is the country profile.
Thanks, Meg. So I don't see any more listed in the Q&A. So Shirley, could we check and see if there's anyone who has a question waiting on the line?
Certainly, and on the phone lines, if you'd like to ask a question, you may press star followed by 1 and record your name clearly. Again, that was star followed by 1. And one moment, please, for our first question. We do have someone that is queued up, and I'm going to go ahead and open the line, and you can ask your question. Again, if you press star 1, go ahead, your line is open. You may ask your question. And at this time, they're not responding. Again, if you do have a question, just press star followed by 1.
Well, we have another question in the Q&A section, and it says, what if a state doesn't currently offer one of the limited services, the specific measure? For example, paternity establishment only.
This is Meg. The specific measure listed in Article 7 is assistance in establishing parentage. So I think an example would be what Bob mentioned, helping with genetic testing.
As Bill pointed out, it's going to be very important when you make your request to explain why you need it, particularly for the mandatory requests under Article 7.1. You want to frame the request in terms of why it is necessary in order to assist the applicant in making the application or in determining whether the application should be initiated. The stronger you can make that case, the more likely the requested central authority will be to respond favorably.
We do have a question on the phone lines if you'd like to take it.
Sure.
Thank you. And that comes from Victor Brundage. Your line is open. Go ahead with your question.
Hi, I have a quick question for you. Good afternoon. Hello?
Hi. Good afternoon.
Yes, so we have a little confusion on our side, so I need some clarification. When it comes to a U.S. court order on an outgoing transaction, is the U.S. court order considered correspondence? Because I recall you saying that all correspondence was agreed upon. There were two languages of correspondence, English and French, and that most countries had accepted like English as the correspondence language. Do we have to have the court orders translated to the local language, or can they be in English or French?
This is Liza, when you prepare the application, it will indicate what documents you need to include, and those documents, which would be the court order, would need to be translated into according to whatever language the other country required. So that would not be considered a communication. Communication would just be like an email, and this is what I'm understanding, and Meg can jump in, but email, just correspondence in conversing about the case, but your formal application that you put together will have documents, including the court order, and those documents will need to be translated according to whatever language the country indicates.
You want to look carefully at the profile. Some countries may be perfectly willing and even prefer to have everything in English because they don't trust our translation capabilities. And also, there may be the possibility of sending an abstract or an extract of the order. You may have a 40-page dissolution decree, but there may only be 3 pages that pertain to support. And some countries will be perfectly happy just to get those 3 pages.
Thank you. Are there other questions, people waiting on the line? Shirley, do we have anyone else?
We do have a question. Jeanette queued up, and go ahead with your question, Jeanette.
Mike, could you give us an example of a specific measure that might be requested under Article 7.2?
You know, the sky is the limit. It merely has to have an international element concerning the recovery of maintenance. And this is where possibly establishment of paternity might work. If I'm not going too far, it might even, work in a case for a debtor. There are no particular limits under Article 7 as there are for applications for the debtor. And it may be a situation in an ideal world where the debtor would like to have paternity established. And this certainly wouldn't fit under any of the normal applications, but it has an international element, and it might be something that you'd want to give a try.
Okay, thanks.
Another, if you would, if you look at the slide 11, that lists all of the different Article 6 functions that a central authority has to provide, only some of those are listed in Article 7.1, and Article 7.2 isn't limited to the measures listed in 7.1. So in addition to what Bob mentioned, it could also be anything listed in Article 6 that goes beyond those 6 that are pulled out specifically. So that just would give you some other examples.
Okay.
Not to advance a legal opinion by any means, but some of us might even argue you could go beyond the measures listed in Article 6. Nothing I say by any means should be construed as an opinion of the Office of the General Counsel.
So noted.
We do have another question coming in. One moment, please. Our next question comes from Andrew. Your line is open. Go ahead with your question.
Hey, I don't know if this is looking too far ahead, but as far as correspondence goes, do you know if CESNET is going to be tied into the iSupport system? And if you do, if there's like a timeline to when we can start communicating with countries via CESNET?
Andrew, this is Ann. Thanks for your question. For folks on the line, iSupport is a case management system that's been developed by the Hague to transmit Hague Convention cases and cases among the EU countries. OCSC is actively involved in assessing iSupport. We're looking very critically right now at the security and privacy provisions of the system in making our decision when to move forward. So the answer to your question, Andrew, is we don't know yet. We're not to the point of making a final decision on iSupport and how it would be configured in the U.S.
Thank you. And at this time, I'm showing no further questions.
Thanks, Shirley. And I don't see any new questions coming up in the queue. So I think we'll go ahead and wrap up. So the next slide, that would be slide 27. We'll list the upcoming dates for the next module, and you may have questions after today about this module or implementing the convention in general. And our OCSC's Division of Policy and Training will continue to provide guidance on the implementation issues, and that is the purpose of this webinar. And so the next module, we're going to begin our focus on case processing, starting with the most common application, which is recognition and enforcement of a convention order, and it will cover the incoming applications to the U.S. So go ahead and add these dates to your calendar if you want to attend them. Watch for the registration. We'll only be sending it out a couple weeks ahead so that people can make sure that they can commit to attending. You do need to register separately for each module. So if you notice the time is coming close and you haven't seen notice of it, you can always contact us, but we will attempt to get the notice out to the people who have attended this module. So last slide lists the contact information, the 2 email addresses you can use to contact either OCSE through the international address or Meg Haynes. So let's see, it looks like we've got some more questions coming in. And it looks like it's on translation and more on, let's see, specific measures. I don't know, they look quite long, so I don't know if we have time to cover them today. So maybe we can pick those questions up on the next call. Does that sound like a plan?
That sounds good, Donna.
Okay, thank you everyone for attending this webinar, and we hope you'll be able to join us for the upcoming 6.
Thank you, and that does conclude today's conference. We thank you for your participation, and at this time you may disconnect your lines.